Hi everyone, welcome back to iExamB. I'm Indira and today we are diving into a crucial change that's shaking up the dreams and plans of thousands of judicial aspirants across the country. If you have been preparing for judicial services or just graduated from law school hoping to write the exam, this is something you absolutely need to know. On 20th May 2025, the Supreme Court of India reinstated a rule mandating a minimum of 3 years of legal practice to be eligible for civil judge junior division exams. And as a consequence of this, the freshers straight out of law school can no longer directly appear for these exams. This move has sparked intense debate. Is it a step towards strengthening the judiciary or is it a roadblock for young aspirants? In today's video, we will break this down comprehensively. We will look at what exactly has changed, why this decision was taken, whether it's fair or not, and most importantly, what can you as an aspirant do now to move forward smartly? I promise that by the end of this video, you will not just understand the change, but you will know exactly how to navigate it. So let's begin with what has changed. Previously, was required and a candidate required an LLB degree from a recognized university to be eligible to sit for the state judiciary exams, meaning a fresh law graduate was eligible to appear for such exams. However, as per the Supreme Court's recent judgment, all candidates applying for the civil judge junior division exams across India must now have a minimum of 3 years of experience as a practicing advocate or as a law clerk. And here's the key detail. This experience is counted from the date of your provisional enrollment with the State Bar Council and not from the date you pass the All India Bar exam. Right? So this means technically your clock starts ticking the moment you get enrolled after your law degree, even if you have not cleared the All India Bar exam. But how do you prove this experience? So the judgment clarifies that the experience must be certified either by a principal judicial officer or by an advocate who has 10 years of standing at the bar, right? And in order for this certification to be valid, it must be endorsed by the local judicial officer. Now, this is not just a formality. It requires maintaining detailed records of your appearances, cases, drafting work, as well as other court related activities. Now, let's understand why this change was made. Interestingly, this isn't the first time, this 3 year experience rule was introduced. Back in 1993, the Supreme Court in All India Judges Association case had initially mandated this requirement based on the view that judges must have hands on experience with the courtroom environment before taking on such a critical role, right? However, in 2002, following the recommendations of Shetty Commission, right, this requirement was removed to make the system more inclusive and accessible for fresh law graduates. Now, for over 2 decades since, states allowed direct recruitment of judges from among freshers. So, what changed now? Why did they go back to the previous rule? Now, according to the court, various high courts across the country had raised concerns. They observed that the judges with no courtroom experience were struggling with essential judicial functions like case management, dealing with lawyers, and understanding the real world litigation. So, as the Supreme Court puts it, neither book knowledge nor pre-service training can substitute the insight one gains from actual legal practice. In other words, it emphasized that experience matters. Right? Now, this ruling is essentially aimed at improving the quality of the judges, right? The quality of the judiciary by ensuring that judges have some real world exposure before they enter the system. But is this fair? Let's pause and weigh both the sides, right? On one hand, the move can be seen as a step towards building a more competent judiciary, right? Having worked in the trenches of courtrooms, a candidate will have already dealt with clients, learned to draft pleadings, understood how hearings work, and experienced the pressures and nuances of legal practice. So when they take on the role of a judge, right, they are better equipped to handle complex situations. On the other hand, the impact on young aspirants is also undeniable. Many law students plan for judicial exams from their second or third year of college, dedicating their entire academic journey to this one goal. So for them, this ruling suddenly pushes their timeline forward by 3 years, right? So it creates uncertainty, especially for students who come from modest or economically weaker backgrounds, who may not have the means to sustain themselves while waiting to become eligible, right? Because there is a cost of setting up practice, right? There are challenges of finding mentors. And most importantly, the unpaid nature of early litigation work can all become very overwhelming. So, what now? What should you do if this change has affected your plan? Now, first and most importantly, do not panic. Instead, treat this 3 year period as an opportunity to grow stronger, right? You join uh, a practicing advocate as a junior, right? You can work in trial courts where you can learn drafting, filing, as well as case representation from scratch, right? Another thing is that you can also start judicial clerkship, as that experience is now recognized under this rule, right? Again, judicial clerkships will also offer you an inside perspective as to how judiciary works, right? So again, a very good opportunity which is also recognized as a part of this 3 year mandate. Now, another important thing is that you have to keep meticulous records of your work, right? You have to maintain detailed work records, meaning you have to maintain a logbook of case appearances, court dates, drafting assignments, as well as client consultations, right? So, this will help you when it's time to get your experience certified. Secondly, you can use this time to keep preparing academically, right? So you can continue your judicial preparation alongside this practice, right? The judicial syllabus is not going anywhere. So you can continue it side by side, join weekend classes, enroll in test series, keep writing and evaluating answers. So these 3 years can make your foundation rock solid if you utilize them wisely, right? Then you can also utilize this time to build your legal personality. Write articles, attend workshops, join bar association events, right? Start creating a presence in the legal ecosystem so that by the time you're eligible to apply, you are not just prepared, but you're also visible and respected, right? Lastly, you also have to stay informed, right? You have to stay updated, right? Each state will take at least 3 to 6 months to amend their recruitment rules. So keep checking the websites of the high courts and state public service commissions. Don't rely on rumors. Follow verified legal portals like Live Law, Bar and Bench, and SEC Online for updates. Right? Lastly, if you're feeling disheartened, remember that remember this, becoming a judge is not just a career goal, it's a service to the nation. And any service that serious deserves real preparation. So, if the system now asks for 3 years of dedication and learning before you take the chair, use that time to your advantage. It's not a delay, it's a refining period. So, that's the complete picture. Is the 3 year rule fair? Maybe yes, maybe not for everyone. But what matters more is how we respond to it. If you adapt, grow, and stay focused, nothing can stop you. If you found this video helpful, make sure to like it, share it with your fellow aspirants, and hit the subscribe button. I'm here to guide you on every step of your legal journey. Drop your thoughts in the comments below. What do you think about this rule, whether it's justified or not, and how are you planning to navigate it? I'd love to hear from you. Until next time, stay resilient, stay curious, and keep hustling. Thank you so much.